If an individual in Colorado is charged with a crime, and if the attorney successfully negotiates with the prosecutorial staff, state or federal level, sometimes, if they're not going to go to trial, sometimes he's able to convince the prosecutor to give you what's called a deferred adjudication. Sometimes it's referred to as a deferred judgment. What that means is a person goes and pleads guilty, but the guilty plea is deferred, put off, not entered. You're not convicted yet. If you ever have to testify during that period of time, he can still be brought up that you have this crime you pled guilty to. But after your period of probation for the DJ, or deferred judgment, as we refer to it often in Colorado, after it's passed and you've successfully done whatever you have to do as a condition of, they call it probation at that time, but you really don't have a guilty verdict entered yet, it's deferred. And say you've got to do things for a year as a condition of your deferred probation, go to classes, whatever's appropriate for your case. After that year, if you've successfully done what you're supposed to do, the judge will note what's called a paper review, that you've done everything you have, there's no objections to have you done your probationary period, and the case is dismissed. There was never a conviction. And then you have the right to hire an attorney in Colorado to file, in most cases, there are exceptions, but for most criminal actions, you have the right to then file a civil suit to seal the record so that other than law enforcement authorities, the general public, your employers, that sort of thing, they'll not be able to see this record of what you were charged for. It was deferred. Probation is simply a condition you have to do after you've actually had a good conviction entered against you, either by jury verdict or by plea, and it's there, it's on your record, it's there. You don't seal it. That's the difference.